There are three significant characteristics of the restrictions under Article 19, Clause 2. This structure is common to clauses 2 to 6 of Article 19.
First, the restriction can be imposed only by law or under the authority of law. Second, the restriction must be reasonable. Third, the restriction must be in relation to one of the grounds enumerated under the particular provisions.
The core of these restrictions is hidden in the second condition, that the restrictions imposed must be reasonable. Let us try and understand what the term reasonable implies in this context. What are the factors relevant to the determination of whether a restriction is reasonable?
The Supreme Court has laid down a number of parameters to determine whether a restriction is reasonable. Firstly, there cannot be a straitjacket definition for reasonableness. Restrictions imposed have to be reasonable both procedurally and substantively and will have to be evaluated on a case-by-case basis. There must be a direct and proximate connection between the restriction and the object sought to be achieved. Say, for instance, that a right is to be curtailed on the ground of public order. There must be a proximate link between this object and the restriction that is sought to be imposed. A restriction should also not be excessive. In other words, it should not be disproportionate. This is a key element of reasonableness. A restriction should go no further than necessary while curtailing a right.
In judging the reasonableness of restrictions, the prevailing social conditions and the urgency of the situation are the other factors that the court may have to look into.
Procedural reasonableness refers to the manner of imposing a restriction. This could include non-compliance with principles of natural justice, an aspect that we discussed in Unit 3.
In one of the earliest cases on reasonable restrictions, State of Madras versus V.G. Rao, the petitioners succeeded because they were able to prove before the Supreme Court that their right to form associations had been curtailed by a statute.
This statute permitted the government to declare associations unlawful. Membership of such organizations was an offense under the statute. However, without any effective means of communicating to affected parties the decision that the association was unlawful, this amounted to an unreasonable restriction. This was what the Supreme Court held in State of Madras versus V.G. Rao.
That gives you a sense of what a reasonable restriction is. Now, let us discuss the grounds enumerated in Article 19, Clause 2, on which freedom of speech and expression can be restricted.